Welcome to the details of those stories and more. Now, the Supreme Court has in a unanimous decision ruled that the Electoral Commission's decision to exclude the existing voters' ID is valid. The court also said the Commission has the power to compile a new register and can go ahead with the exercise slated for June 30. Private citizen Mark Techi Benson and the NDC had asked the Apex Court to stop the Electoral Commission from compiling the register or allow the use of existing voters' ID card and birth certificate. Court correspondent Joseph Akable has the rest of the story.
The Commission in its legal argument stated that the existing voter register, which was compiled in 2012 and revised since by limited exercises, has been held by the Apex Court as not being reasonably credible. Deputy Attorney General Godfred Yeboah-Dame urged the Apex Court not to impede the EC's quest to obey the law. The 7-member panel that heard the case was presided over by the Chief Justice Kwesi Yeboah. Other panel members are Justice Jones Doche, Paul Bafo-Boni, Sule Badegbe, Samuel K. Mafusau, Nene Amegacha, and Professor Ashikote. The court in its decision held that the EC is an independent body and will only be directed by the court if it acts contrary to law. It said the Commission can carry out the registration exercise in accordance with CI 126. This CI excludes voter ID card and birth certificates, but allows the use of passport and a Ghana card as source document for prospective voters. The NDC, however, had this understanding of the decision.
The court has just delivered a verdict which has granted our request for the inclusion of the existing voter card as breeder document for the compilation of the register. And I think that we are most grateful. I think that this is the most substantive issue for which we came to court. So we will get back to office and we will address a full-blown press conference on the consequential matters arising. Thank you very much.
How does it make you feel, General?
Well, we feel vindicated because the court itself, in an earlier ruling, has clearly stated that the possession of an existing voter's ID card means that the holder is a citizen of Ghana who is qualified to be registered and to exercise his or her powers. And so the court couldn't have gone back on its own earlier ruling. And it did also admit that the right to vote, once it accrues to a person, cannot be taken back in a whimsical and capricious manner in which the Electoral Commission sought to do.
There is currently just one case before the courts in relation to the compilation of a new register. This is the case filed by Ashaman MP Ernest Nogbe, which is pending at the High Court and due for hearing on Monday, June 29.
Joseph Akable with that report. The Attorney General's office has been speaking on this judgment. A Deputy AG Godfred Yeboah-Dame says the NDC clearly does not understand this decision.
For me, it can only advance democracy in the country in the sense that the very sense of democracy, the protection of the right to vote, the right to the people to elect their representatives, to elect their president, in accordance with the hallowed principle of one man, one vote. And I sought to indicate at the last agenda that indeed the voters register has been shown to be over-bloated. And it has been so since 2012, and it was so again in 2016. It was also, it is so presently. So it has been so since 2012. And if you look at 2012, the declaration of results, the number of registered voters, as declared by the Electoral Commission, was about 14.1 million people. But the total number of Ghanaians over 18 years was, as per the statistics of the Ghana Statistical Service, 13.7 million. So the very obvious question one ought to ask is how can the number of Ghanaians aged 18 and above, who I consider to be the registrable population, be less than the number of total number of registered voters? That is incongruous. It cannot be. And the same pertained in 2016. The number of registered voters was about 15.7. Yet, Statistical Service indicates that the total number of Ghanaians aged 18 and above is about 15.2 million. And you remember that the NDC also was making a point in court that there is supposed to be about 80 million people on the voters register. That was unsubstantiated and totally baseless, because the evidence for the statistical service, which I furnished the court, indicates that the total number of Ghanaians aged 18 and above is 16.6 million people. So where from that figure? They just threw it up in the air without backing it up with evidence, and that's what the people of Ghana were made to believe. And so I think that the court ruling is very good. It protects the right of the Ghanaian to vote, in the sense that it shows that clearly it is intended to ensure that only Ghanaians who are qualified to vote indeed register to vote.
In terms of the ratio of the court, it affirmed the independence of the EC once it's not acting contrary to law, and again gave orders as to compiling the register in accordance with CI 126. I'm sure you have seen what the NDC's General Secretary has been saying. Are you surprised with the interpretation that has been put on the decision of the court, and what is the AG's position on the decision of the court? I'm totally amazed at the ridiculous interpretation that has been placed on the court ruling by the NDC, especially NDC's General Secretary. I mean, clearly, it's only a person who perhaps did not have an understanding of what the court said today who could make such a conclusion. It is quite clear. They have the ruling of the court before me, and you have to just match it against the specific reliefs that were sought by the NDC. And you see that clearly, in terms of the substantive reliefs, they're all dismissed.
And we'll be doing a matching of the specific reliefs and what the court said. But for now, Minister for Parliamentary Affairs, Oseiche Mensah-Bonsu, is jabbing critics who he says are misinterpreting the judgment by the Supreme Court in the NDC versus EC case. According to the majority leader, the ruling by the apex court of the land is clear, and it affirms the EC's position as stipulated in the CI 126 passed by the House.
To me, what I'm seeing here is what I believe is the truth, and this is certified from the Supreme Court. It says, with particular reference to the second relief that they sought, in respect of including the old voters' ID card, the Supreme Court was unanimous in this, that the relief is granted subject to the fact that all eligible voters must make themselves available for registration as directed by the Electoral Commission pursuant to Public Elections Registration of Voters Amendment Regulations 2020 CI 126. As simple as that. What is contained in CI 126 is that they are saying they are going to rely on the Ghana cards, that is the identification authority cards, and passports. That's what is contained in that. So if the court issues this ruling that it should be pursuant to CI 126, who in his wildest imagination will go outside this ruling to say that, the old voters' ID card has been included? The facts speak for itself.
Majority Leader Oseiche Mensah-Bonsu there. The minority spokesperson on Constitutional, Legal and Parliamentary Affairs, Inusa Fuseni, says the ruling by the Supreme Court is a victory for Ghana's democracy. He's insisting that granting of Relief 3 of the NDC subject to CI 126 means the existing voter's ID card must be admitted as a primary document for registration.
The NDC went to court to pursue certain reliefs. NDC was put to an election. NDC chose Relief 2. Relief 2 was based on something. And Relief 2 by the Supreme Court has been granted. The Supreme Court decision grants Relief 2. That was what we pursued in court. We didn't go to court to ask the Supreme Court to uphold CI 126. NDC did not go to court for the Supreme Court to uphold CI 126. NDC went to court and said that, look, if you look at the voter registration exercise to be carried out by the Electoral Commission, the Electoral Commission by CI 126 is seeking to remove from the list of primary documents for identification the existing voter ID card. And that existing voter ID card read which is issued pursuant to CI 91, derives its foundation from CI 42, and read together with CI 51, vests in the Ghanaian an accrued right. Immediately you are registered in Ghana, you have an accrued right to vote under Article 42 of the Constitution. The Supreme Court said, yes, we'll grant you that. What does it mean? Yes, so it means that, it simply means that CI 126 and the primary documents listed therein are relevant for the registration of voters as the decision to grant the accrued rights. That's all.
Inusa Fuseni there. Well, the Electoral Commission says it is all set for the registration to begin, and nothing less than identification mentioned in the constitutional instrument 126 will be accepted on Tuesday, June 30, when the process begins. A statement issued a few hours ago by the election regulatory body said all stakeholders should prepare for the exercise next week. And here are excerpts of that statement. It says the Supreme Court, in a unanimous decision today, Thursday, the 25th of June 2020, dismissed the cases brought against the Electoral Commission. The Supreme Court directed the Commission and all its stakeholders to comply with Articles 42 and 45 of the 1992 Constitution and CI 126, Public Election Registration of Voters Amendment Regulation 2020. The statement goes on to say, for the avoidance of doubt, CI 126 spells out the requirement of proof of identification for the purposes of registration. It states as follows: 3. A person who applies for registration as a voter shall provide as evidence of identification one of the following: A passport; 2. B, a national identification card issued by the National Identification Authority; or C, one voter registration identification guarantee form as set out in Form 1 of the schedule that has been completed and signed by 2 registered voters; and A, by the substitution for sub-regulation 4.4. Despite paragraph C, it goes on and on. A registered voter shall not guarantee the identity of more than 10 persons. Essentially, the number of people someone can help to register. It goes on to say that as a commission which believes in the sanctity of the law, we respect the decision of the Supreme Court. In the words of the courts, the Electoral Commission, in exercising their discretion in the charge of their constitutional mandate in cleaning the voters' register, should be deemed as authorized to be acting within the law and regulations therein. And so the Electoral Commission takes this opportunity to assure its stakeholders that the voters' registration exercise will start from Tuesday, 30th of June 2020 of the 6th of, to the 6th of August 2020. The Commission entreats all stakeholders to hold themselves in readiness for the voters' registration exercise. It finally adds that the Commission will enforce strict safety protocols at its registration centers across the country so as to protect applicants from the COVID-19 pandemic. May God bless our homeland, Ghana. It ends, and it is signed by Sylvia Ano, Acting Director of Public Affairs.